All right, Ms. Favors, your case, we're going to go on the record, is 24 SC 004363. And today is your final plea date. That's just the last day you could enter a plea if you wanted to enter a plea, and you may not, when you would have the right to withdraw that plea if I sentenced you to more than what your lawyer asked for. It's kind of an academic exercise in your case. Charged with murder, your lawyer could not ask for less than a life sentence, and you might not be interested in pleading to a life sentence. So unless the state is offering some reduction in the charges, if you were to plead today, it would be to murder, and the debate would be, is it life, life without parole, something in between. But Ms. Wood has already given me a forecast that you're not inclined to plead to an offer of life. But I'm going to ask Mr. Abate, the prosecutor, to put on the record what the state's offer is if you decided that you wanted to enter a plea today. Okay? Mr. Abate, what would the state be recommending?
The state's recommendation today would be life, with the possibility of parole, and then the possession of a firearm would run consecutive 5 years. That's enough.
Okay.
But, I will put on the record that me and Ms. Woods and I are still very much negotiating and talking about the case. I know it feels like it's probably been a long time, but because of the amount of murders that we have, this is one that we just recently started to truly negotiate.
Got it. Okay. So, Ms. Favors, if you were to enter a plea today, the only offer from the state would be a plea to the indictment as charged, and the state would recommend the lowest they could recommend, which would be life with the possibility of parole, plus 5 years consecutive, but those years are suspended because it's alleged you used a gun to commit the murder that you're alleged to have committed. Is that something you're interested in pursuing today?
No, I'm not.
Okay. Ms. Wood, any issues with discovery?
No, Judge, I believe I have everything. We have gone over it, and then I have one other thing I'm going to show her while she's here today.
Okay. Great. Ms. Favors, I'm going to move your case to a trial calendar in April, so next month.
April 3rd.
Yep, exactly. Hopefully between now and then, Mr. Abate will have more time to work with Ms. Wood to see if there is some kind of negotiated resolution, but you may just want a trial. You have a right to a trial, and then we'll make that happen. So we are continuing to move your case forward, and I will see you either for that trial calendar or before if something has been worked out. Okay?
Just for the record, the only thing that is outstanding is unfortunately, the obvious and always is the
Ballistics.
But that, in this case, it's not going to be something that's life changing if it doesn't come back at the time of trial. She was found with a gun in it, so we're all right.
Okay, got it. That wouldn't be a reason the state would seek to delay the trial.
That's correct. Yes.
Understood. Okay, so we are on track, Ms. Favors, and I will see you at the latest in early April. Okay?
Yes, sir. Could I ask you a question, please?
You sure
The
can.
last time I was in front of you, I know that you answered a plea on my behalf for not guilty, and you said that we would be doing immunity on the charge. How do I get?
So I don't know that I said anything about immunity. Ms. Wood may have, or you may have asked about that, but the subject matter expert on that would be Ms. Wood. She has looked at the state's evidence, and if there is no immunity motion in the docket, that means Ms. Wood has looked at it and said it would be frivolous to file an immunity motion because if I were to look at it, there may be a self-defense argument, and that may be the argument that Ms. Wood would make if this goes to trial, but it doesn't rise to the level of giving you absolute immunity where the charges need to be dismissed. So watch the video that Ms. Wood has that she wants you to look at, chat with her about why no immunity, listen to what she has to say, and remember, she's the lawyer, and so she knows what the law is around that. I know you may hear while you're in custody, people's like, oh man, you need immunity motion and this and that. It's not that simple. It is understandably a pretty high burden for a defendant because if you succeed with immunity, I throw the case out, and there's someone who is dead. So I know you understand, you were there, but it's not all that common that a case gets thrown out. That doesn't mean you don't have a great immunity argument. Talk with Ms. Wood about it and hear what she has to say about it, okay? Again, I will see you at the latest in early April, okay? Thanks, everyone. All right, Ms. Cabrera, you're still here. Poor Mr. Cardbow had to crank his neck pretty hard. It's just sort of natural to be turning towards the person who's asking you the questions. So if you don't mind doing that, that would be great. And I'll get that added in a minute. So Ms. Grubbs is suing the city of Atlanta for $30 million because they denied her a permit to run an ice cream truck.
Wow.
Pro se? All right. We've been around and around on a lot of things in that case. But we've got Mr. Cook, which is position 2 from this afternoon's calendar. And my understanding, Mr. Cook, is that you are prepared to enter a plea in, I think it's 2 cases?
Yes, sir.
And we're going to get you to Hope House.
Yes, sir.
All right. Ms. Dilligard's going to put you under oath. Once you're under oath, it's important that you listen to her carefully and answer all her questions truthfully. If you've got any questions of your own, let me know. And Ms. Wood or I will answer those questions for you, okay? All right, Ms. Dilligard, when you're ready.
Mr. Cook, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please state your true and correct legal name for the record.
Vincent Edward Cook.
Mr. Cook, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you have not taken or been given today?
No.
How old are you and how far have you gone in school?
I'm 58. I graduated high school.
Do you understand that you've been charged with the following offenses? In indictment number 24 SC 001583, it's 1 count of theft by taking. And then 25 SC 000034, it's 1 count of possession of methamphetamine.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charges in these indictments, including the facts and circumstances relating to those charges?
Yes, ma'am.
Would you like more time to discuss the case with your lawyer? Are you satisfied with your lawyer's services?
So, Mr. Cook, please let Ms. Dilligard finish her question. I know you know the answer. There's no early buzzing in. The court reporter can only take down one voice at a time.
Okay.
So let her finish and then yes, ma'am, no, ma'am, whatever your answer is.
Fine.
Thank you.
Counsel, do you waive formal reading of the indictment and any and all defects in the indictment for purposes of the plea?
So waived.
Mr. Cook, do you remember being arrested for both of these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today? For the theft by taking, the minimum is 1 year, the maximum being 10 years. And on the possession of methamphetamine, the minimum being 1 year, the maximum being 3 years.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is 5 years probation for both cases, on the condition that he enters and completes Hope House, 60 hours of community service, and a stay away from both incident locations. And then in the theft by taking, it's no contact with the victim, Gloria Parker.
Is that a stranger to him as far as you know?
As far as I know, it's a stranger.
Okay.
Yeah,
Oh.
kind of. I knew her. She
You
You know,
still
it-
know her?
no, I don't talk to her no more.
Okay, but it was someone you knew.
Yes, sir.
Okay.
Okay. Is that your understanding of the recommendation, Mr. Cook?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
And do you understand that there's multiple charges which you're pleading guilty to today, that the court has the right to run those sentences consecutively?
Yes.
And do you understand that if the court decides to enter a sentence that differs from the negotiated plea that you were expecting today, that you'll have the right to withdraw that guilty plea?
Yes, ma'am.
Are you currently on probation or parole?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
And do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Cook, how do you plead to the charge of one count of theft by taking an indictment number 24 SC 001583?
I plead guilty.
And how do you plead to one count of possession of methamphetamine in indictment number 25 SC 000034?
I plead guilty.
Is these guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
And do you understand that you have a limited right to appeal this guilty plea conviction?
Yes.
And do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
You understand that for a felony charge, you only have 4 years from today to file a habeas corpus petition? Judge, in 24 SC 001583, if that case were to proceed to trial, the state contends that the evidence would show that on October 2nd of 2023, Roswell Police Department responded to a suspicious call at 10475 Alpharetta Street. When they arrived, they noticed that the suspect had a very distinct limp, and it was flagged in their minds. They had recently saw a bolo matching that description of Mr. Cook for a theft by taking of a 2014 Hyundai Santa Fe that belonged to Gloria Parker. Officers then reviewed the surveillance video of the theft by taking and determined and confirmed that it was Mr. Cook in that video. He was also wearing the same clothing that he was seen wearing in the surveillance video when they approached him on that day. All that occurred in Fulton County, Georgia for that case.
Okay.
And then for the possession of the Schedule 2 methamphetamine, this incident occurred on August 27th, 2024, while on patrol, officers noticed the defendant was lying on a bench in front of a shopping center after business hours. They approached the defendant. He refused to identify himself and stated that he didn't remember his name. He was detained so that officers could work on identifying him, which they were able to identify him as Vincent Cook with an active warrant. A search incident to arrest produced drugs found in his pants and sock, and the GBI report confirms less than 1 gram of methamphetamine on that case. That also occurred in Fulton County, Georgia. Judge, the defendant, from my notes, has 5 felony convictions. I know you'll hear that shortly, but that went into account. It seems as though that the services that Ms. Wood aligned for will be best, and so we're asking that the court accept our recommended plea.
Okay. Thank you so much. No restitution for the Hyundai Santa Fe owner?
No restitution.
Okay. All right. Ms. Jackson, if you could share with me, please, what you have on Mr. Cook.
Yes, Your Honor. He has 16 cycles. The last arrest was February the 22nd, 2024 in Fulton County for a failure to appear. He does have prior felony convictions. It's one in 2000 for armed robbery and possession of a firearm by a convicted felon. One in 1992 for criminal damage to property in the 2nd degree. An additional one in 1992 for theft by taking. And there was one in 1991 for theft by receiving stolen property. Nothing in addition, Your Honor.
Thank you so much. Mr. Cook, I'm going to hear from Ms. Wood in just a moment. Your armed robbery, was that a trial or a plea?
A plea.
How long did you go to prison for?
Stayed at 10 years. Got out in 2009. And got
So it was the full 10 years
Yes, sir. Never got in trouble since then.
until now?
Yes.
Okay.
I slipped up and got back and started doing drugs, and I slipped up and really
Okay.
slipped up, man.
Well, we're going to try to help you unslip now.
Yes, sir. Thank you, sir.
Ms. Wood.
Thank you, Judge. He's 59 years old. He is a lifelong Atlanta resident. He's a high school graduate, as you heard. He has one adult child. He was working odd jobs before his arrest, so most recently doing car washing. And he was accepted into Hope House. We have the transport date. I've sent that to Ms. Nelson. He's a trustee at the jail. He's eager to get into the program and get back into a sober lifestyle. He's been in collectively 200 days for these two cases. So he is eager to go, Judge. We would just ask that you accept the state's recommendation.
Okay. The usual question, why not drug court for Mr. Cook?
Yes, Judge. And I meant to tell you. So when I received his case, there was actually there was the one indicted and then two unindicted, and they actually ended up merging those two unindicted cases into one. One of our pre-indictment attorneys had actually looked into drug court, and so I thought he was actually gearing up to go into drug court, and there was some sort of miscommunication. By the time we squared that away, Ms. Ross had already plugged in with Hope House.
Okay.
I say all that to say that I hope that we don't have any issues with Mr. Cook, but now knowing what I know, we do have drug court.
As an option, fallback. Got it. That's good to know. Mr. Cook, anything you want to add to what Ms. Wood just said?
I just want to thank you, sir. Just give me another chance in life, man, because, I fucked up. I messed up pretty bad, but...
What you did way back when, 10 years, you lost.
I didn't do it. I didn't get in no trouble, but when I thought my brother died in my arms, I'm not saying that caused me to do drugs, but it didn't help. It didn't stop me from doing it neither. I started, I picked up on drugs again.
Okay.
Because it helped me get rid of the sin in my arms all the time. You know what I'm saying?
Yep. No, I do. And
I needed that.
A loss like that actually can cause you to relapse. You lose someone close to you and your world is shaken up, and to get comfort and deal with the grief, it's a bottle of liquor or it's a hit of that. And the next thing you know, you're back into the addiction. So, Hope House is an opportunity to try to turn that around.
Yes, sir.
What you need to understand is that, you need to take it seriously because I'm going to take it seriously.
I'm taking it seriously,
If I hear from probation that 2 months in you walked away from the program or they had to kick you out because you were doing something you weren't supposed to do, I'm going to have to think hard about whether we do. I don't know if you ever heard of RSAT. But that is drug treatment, but it's drug treatment where the doors lock on the outside. You're basically in a jail facility that gets you drug treatment.
Yes, sir.
So you are forced to do the drug treatment because you can't get out. That is one way to do it. It's not the best way because you're not there voluntarily. Yeah. You want to be at Hope House.
Yeah.
And I want you to stay at Hope House for the duration of the program. We also have drug court as an option, and I'm going to give you a bunch of probation time so that if Hope House doesn't work out quite right, but the real issue is your addiction, maybe we can try drug court. Although Hope House is generally viewed as more intensive treatment than drug court.
Yes, sir.
So, Mr. Cook, I find there is a factual basis for your pleas in both the theft case and the drug case, in that your pleas are knowing and voluntary. Knowing means you've understood what we talked about. Voluntary means no one is forcing you to enter these pleas. Do you agree with that?
Yes, sir.
Then I'll accept your pleas. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that while you're on probation, if you have a minor issue, probation and you will work through that. You don't have to come see me. But if you get arrested again, you get kicked out of Hope House, that comes back to me and we will figure out what needs to happen after that. Ms. Wood, can someone in my office sign the 2 indictments on your behalf?
Yes, Judge.
Ms. Dilligard?
Yes, Judge.
Mr. Cook, is it okay if we electronically sign your name on the indictments indicating you're guilty, please?
Yes, sir, you could.
We will do just that. So, Mr. Cook, on 24 SC 001583, I'm sentencing you to 5 years to serve 6 months with the balance probated. Special condition of your probation number 1 is that you enter into and complete the Hope House program. Special condition means if you mess that up, I can work with all of your probation in figuring out a remedy. You'll also need to complete 60 hours of community service, stay away from the young lady whose car you took, and have no contact with her. In 25 SC 000034, I'm sentencing you to 3 years to serve 6 months with a balance on probation. Special condition of your probation there is that you enter into and complete the Hope House program. You'll get credit for the 6 months you've already done in both those cases. I'm going to need to talk with the jail to make sure you don't get released early. Ms. Wood has sent me a transportation order that directs the sheriff's team to deliver you to Hope House next Thursday.
Yes, sir.
And so you're going to be in custody until next Thursday. You'll hop in a van or a patrol car, they'll get you to Hope House, and that's your new home. Don't quit the program. You need it, you need to want it, and I hope you succeed in that program. Because if you don't, we'll have to get back together and come up with a different option of some sort. Okay?
Yes, sir.
Any questions about any of that?
No, sir.
All right. Ms. Simpson, what do you need to tell Mr. Cook about probation?
Would he be able to report once we get open?
I don't know how that works. I think initially at Hope House, you're not supposed to leave those first bunch of weeks. So we'll have an address for him. It's Hope House. It's in Fulton County.
That part won't be a problem. It's just a matter of how to determine for him to report. What I can do.
You know, they have escorts there, and I bet they would escort him to probation.
I think they'll bring him to probation.
Yeah.
Last time I asked about that, that was the case.
Okay, so what you can do then, is you will report to the Atlanta office, which is going to be 276 Memorial Drive. And that is right around the corner from here. And so your reporting date will be March the 20th. Before, let me ask.
Oh, wait,
Yeah, let me ask, what is his transport name?
March the 20th.
Yeah.
Okay, so I'm gonna start from his transport date, Judge.
Mm-hmm.
Instead of starting from today, we'll make his transport date.
For a certain time, 8:30.
It should be 8 AM, but with Hope House, I don't know how they
Okay.
handle it. So as long as it's between 8 AM and 11, that's when they do it.
Got it. Thank you.
You got it?
Thank
sir.
you,
All
Jeff.
right, Mr. Cook. Good luck with things.
Yes, sir. Thank you, sir.
All right. There you go.
Thank you, ma'am.
Oh,
God
no,
bless
you
you,
got
sir.
this, Mr. Cook.